All right. Hello, everybody. My name is Gabby. I am our Community Education and Outreach Coordinator here at Legal Aid. With us today, we have Janet Coleman, who's going to be presenting on wills and advanced directives. This is going to be a talk on end-of-life documents. If you're unfamiliar with our Listen and Learn presentations, what's going to happen is Janet is going to go through a PowerPoint presentation, again, today talking about end-of-life documents, wills and advanced directives, all of that. And then at the end, we're going to have a chance for a question and answer session. So if you're viewing on Zoom, you can put your questions into the Q&A box at the bottom left-hand side of your screen. I'm sorry, in the bottom middle of your screen. And if you are viewing on Facebook, you'll be able to put them into the comment section. It can be either below the video or to the right of the video, depending on if you are viewing on a computer or a mobile device. Just a couple ground rules when we're asking questions. Keep in mind, this is a public forum. Anybody can see anything you say. So be mindful of any revealing information. This recording is also being posted to all of our social media pages, so anybody can also view this later and see your questions and all of that. So be very, very mindful. Additionally, Janet is an attorney, but she's not your attorney, so we can't answer anything very, very specific to your situation personally, but we can answer general questions. So again, keep that in mind. Questions can go into the Q&A box on Zoom or the comment section on Facebook. Yeah, without further ado, I'm going to pass it over to Janet and we're going to get started.
Good afternoon, everybody. So today we're going to be talking, next slide, please. We'll be talking about some different things, basically common end-of-life planning documents, what is required for signing those documents, and I will be introducing myself first. If you go to the next slide, please. I grew up in Rhode Island. I moved to North Carolina to attend college at Davidson College in North Carolina, and then went to Campbell Law School. I was in private law practice for many years. Then I joined the DA's office. I was an assistant DA for over 22 years and then joined Legal Aid in March of 2022. Currently, I work as a staff attorney for the Senior Law Project. We are a special project within the Legal Aid umbrella, and we actually serve only clients age 60 and over. So that is considered a senior for us, and we do many different types of legal work for our seniors. As Gabby said, I can only give general information. I cannot answer specific questions or give legal advice for your specific situation. And also, I will be discussing only North Carolina law. So if you live in another state, the laws for your state may very well be different, although North Carolina does strive to emulate other states in this particular area of the law. They still may be very different. Legal Aid of North Carolina is a statewide nonprofit law firm. We provide free legal services in civil matters only, not criminal matters, to low-income people in order to ensure that there is equal access to justice and to remove legal barriers to economic opportunity for our clients. Legal Aid of North Carolina handles many different types of cases, but some of the more common ones are obtaining domestic violence protective orders, or what's called a 50B or a 50C, to protect survivors of family violence. We also help tenants fight evictions. We assist homeowners in foreclosure. We fight illegal termination of public benefits such as food stamps, Medicaid, and other public benefits. And we also assist in stopping illegal debt collection against our clients. So the common end-of-life planning documents, there are 4, sometimes they're referred to as estate planning documents. And these are general categories. The first is a will, then a financial power of attorney or a power of attorney, and then specifically a healthcare power of attorney for medical and healthcare decisions, and last, a living will. So why, people say, why should I have estate or end-of-life planning documents? Well, one of the reasons is that these documents can be helpful to you and your loved ones if you become sick and or incapacitated. In other words, you're unable to make or communicate those decisions that you may have made. They can help make sure things happen the way you want them to at the end of your life and after you pass. So, you are making the decisions about your own life rather than someone else imposing their decisions upon you. These could be especially important if your biological relatives are not the people that you want assisting you in an emergency or inheriting your property after you pass. So what is a will? A will is a legal document that sets out who inherits your assets after you pass away and who is to manage the property until it is passed on to your heirs. Your will describes who gets your assets, such as your real estate, your car, your money, other property after you die. And it also describes who handles the paperwork to make sure that those people indeed get the property that you want them to have. A will does not take effect, and it has no effect and no meaning until the day that you pass away. So you could change your will every day of your life if you wanted to, as long as you are still mentally competent. The only will that will be followed is the last one that you executed before you passed away, the last one you signed. The will does not transfer any ownership interest in any property while you're still living. So even if your will says that your house is going to your daughter, as long as you're still competent and you're alive, you can still sell that house and your daughter just doesn't get it. If you die without a will in North Carolina, your property does not go to the state. That's a common misconception. Rather, your assets pass by the North Carolina laws of intestacy. Basically, your assets go to your closest family members, but only through legally recognized relationships. Exactly who gets your property depends on a lot of factors like the makeup of your family, how your assets are titled, etc. You should always speak to an attorney about your specific situation if you have concerns or questions about who your property will go to if you pass without a will. If you die without a will, sometimes people say, well, Medicaid's going to get my estate. Well, it can happen that they will if you owe money to Medicaid for long-term care that you have received, and they can go after your property after you pass away, but that has nothing to do with whether or not you have a will. Medicaid estate planning is very complex. The rules change periodically, and you should always speak to an attorney about your specific situation. Again, I'm speaking in very general terms and not in specific situations. So when you have minor children that you are responsible for, or a disabled adult that you care for that resides in your home, in your will, you can nominate somebody to become the guardian of that minor child or children, or of that disabled adult over whom you have guardianship. Just because it's in your will does not bind the court to accept what you have requested in your will, but it is persuasive to a judge. There is also something called standby guardianship that does not go through a will, and that is done in advance. You set it up for someone to be a guardian over that minor child or disabled adult, and you do that through a petition in front of the clerk. So, for example, if you know that you have a fatal or progressive chronic illness that will result in your death, then you could petition the clerk of court to set up a standby guardianship for that minor child or disabled adult that you're responsible for. A financial power of attorney, usually when people say just use the term power of attorney, they usually mean the one for financial affairs. They'll refer to a healthcare power of attorney as a medical power of attorney or as a healthcare power of attorney. A financial power of attorney is a document that names someone to help you out in financial matters. The person who helps you is called your agent, although people often use the term POA or power of attorney for the actual person. So for example, if you have an unexpected accident and go into a coma, your agent, if you've got one and you've named one in a financial power of attorney, Then they could call your mortgage company to ask if your payments have been paid, write a check to make your payments, take care of your financial matters, your business transactions that are required to be taken care of. Some of the things that your financial power of attorney or agent can do for you include write checks from your bank account, transfer money from your savings account to your checking account, call your car insurance company to cancel your car insurance if you no longer need it, call the county tax office to see if your real estate taxes have been paid up to date and in fact pay them if not, buy or sell your assets or buy assets on your behalf, handle a lawsuit on your behalf, and anything basically that you could do for yourself. A power of attorney can take effect in two different ways. It can be one, you can choose that your agent be able to help you right away, which doesn't mean that you can't act for yourself. It just means that someone else is also authorized to act on your behalf if you're unable to do that for some reason. Or it can be what we call a springing power of attorney, which only comes into effect upon some future event, such as if you become incapacitated and can no longer handle your financial affairs yourself. Even though your agent is given access to your finances, the agent is supposed to use your money only in a way that benefits you and you only. So for example, your agent may have the authority to write checks from your account, but they shouldn't be writing checks to pay their own cell phone bills or their own other bills, but rather only spending that money that belongs to you for your benefit. Warning, and I can't stress that enough. The financial power of attorney in particular creates the potential for financial abuse and exploitation because it gives someone access to your money. Agents are not supposed to use that access to benefit themselves, but that doesn't mean it never happens. So you want to be very, very careful who you choose to be your agent under a power of attorney, and choose someone that you trust and that you believe will act in your best interests. Powers of attorney differ from guardianships. Power of attorney by itself doesn't take away any of your own decision-making power. You still retain that power unless you become incompetent. And then you make the choice of who you want to serve as your power of attorney, as your agent. However, if you become incompetent, the court will decide who will have decision-making power and what specific powers they have by appointing a guardian. And that guardianship can be very general or it can be limited in scope. Question we get a lot of times is, how do I get a power of attorney over mom? The answer is you can't. Only the principal, the person that we are helping, we as attorneys can execute that power of attorney. An agent, the helper, cannot execute a power of attorney on behalf of someone else. If the principal is unable or unwilling, such as incompetent, unconscious, or other situations, to sign a power of attorney, there is no way to get one. In that case, the helper must seek guardianship. That would require a court order declaring that principal, that person being helped, incompetent legally. So the next document is a healthcare power of attorney. A healthcare power of attorney names someone to make your medical and healthcare decisions for you if you are no longer able to make or communicate those decisions yourself. For example, if you have a car accident and you're unconscious, your healthcare agent can decide if you should have surgery right away or wait. They are the ones that the doctor will go to ask questions about your care. For example, they can request and review information about your medical condition and consent to its disclosure to other people. They can hire and fire healthcare providers. They can consent to and authorize admission or discharge for you from healthcare or mental health care facilities. They can consent to and authorize administration of medications, surgery, x-rays, anesthesia, and other treatments for you. They can also authorize the withholding or withdrawal of various life-prolonging measures, such as a ventilator, life support machines, things like that. They can also authorize an autopsy or direct the disposition of your remains if that's what's going on at the end, and you end up passing, and you don't have a living will, which we'll talk about momentarily. But basically, any medical decision that you can make for yourself, unless you put limits in the healthcare power of attorney, those decisions can be made by your healthcare agent. The difference between a financial power of attorney and a healthcare power of attorney are pretty straightforward. The financial power of attorney deals with financial matters. The healthcare power of attorney deals with medical and healthcare matters. Having only one of those documents does not give that agent authority in the other arena. So if, for example, you have a healthcare power of attorney, but not a financial one, then that healthcare agent cannot make financial decisions on your behalf, such as write checks or pay bills. So, for example, your agent under the healthcare power of attorney couldn't close out your bank account for you. They don't have that authority under the law or under that document. A healthcare power of attorney, unlike a financial power of attorney, takes effect only if and when you are no longer able to make your medical decisions for yourself. As long as you can make those, communicate your own medical decisions to your doctors, they will always go to you and only you. It only comes into play and into effect in the event you are unable to make or communicate those decisions yourself. A living will, as I said a few minutes ago, is a document that tells your doctors that if you are getting toward the end of your life, you don't want certain extraordinary life prolonging measures, as I said, such as a ventilator, life support machines, things of that nature. It is sometimes called an advance directive for a natural death, and there are other terms used for it, not in North Carolina, but in other states. The difference between a healthcare power of attorney and a living will is that a healthcare power of attorney names somebody else to make your medical decisions if you can't make them for yourself. A living will express your own wishes for your end of life care. There's often some overlap between the two, but it's not a perfect overlap. So, for example, someone might live with dementia for years and need a healthcare power of attorney agent to make everyday healthcare decisions, but not necessarily be at the end of his or her own life. So those decisions as to end of life won't come into play. They won't be effective. The difference between a living will and a DNR, and some people are very familiar with the DNR, is it's a do not resuscitate order. That is a medical order. It has to come from a doctor. That goes into a medical file. A living will is a legal document that you execute yourself, probably with the help of an attorney or a lawyer. A lawyer cannot give you a DNR order. Only a doctor can do that. A living will takes effect under certain specific triggers that you choose. Those triggers include that you suffer from an incurable or irreversible condition that will result in death within a relatively short period of time, or that you are unconscious and to a high degree of medical certainty will never regain consciousness, or that you suffer from advanced dementia or any other condition resulting in the substantial loss of cognitive ability, and that loss to a high degree of medical certainty is not reversible. You can choose any of or all of those three triggers when you're executing a living will. You choose. For these documents to be valid, they have to be executed or signed by the maker, you and others, in a way that is set out by statute. It must be done formally in order for them to be valid and enforceable. For example, if you email your neighbor and you say, I want you to get everything, That's not going to be enforced by the courts. That would not be a valid will. That would not be sufficient to transfer title to your assets when you pass away. Or, for example, a grandfather drives his granddaughter around his farm and says, "This will all be yours someday." That also is not a valid will. That's insufficient. For a valid execution, there are generally 3 requirements. It has to be signed by you, the maker, in front of 2 disinterested witnesses who also signed the document, and acknowledged by a notary, and that applies to all of the signatures, yours and that of those of the witnesses. The financial power of attorney does not require 2 witnesses. It only needs to be signed by the principal, the maker, and notarized. Handwritten wills are something that sometimes people say, well, I've prepared my own will, I've handwritten it out, and it's called a holographic will in the law. This is an option if you can't get to an attorney right away to prepare a will for you. It should only be a temporary stopgap solution, and you should go to an attorney and have a will prepared as soon as it is feasible to do so. For a handwritten will to be valid, it must be written entirely in the handwriting of the testator, the person making the will. It must be signed by that person making the will, the testator. It must be found in a proper place, such as a safety deposit box, or with that maker's, that testator's important papers, or left with someone for safekeeping and told that it was an important paper. And after the death of the maker, 3 witnesses have to testify as to the handwriting being yours, and 1 witness would have to testify as to the will being found with those important papers of yours. If you do decide that you want to write a handwritten will, keep it simple. Distribute the property clearly and with no conditions. In other words, don't say, "To my son, but only if he has graduated high school and had children. If he has not graduated, then property is to be given to the Humane Society, but only if it is run as an animal shelter. If it's not," etc. Identify the property very clearly in a way that even a stranger would understand. In other words, use a street address if you're referring to a piece of real estate, such as 136 Oak Street, rather than the old home place or the mountain house. Describe the property very clearly so that they don't have to refer to other evidence. It needs to be in the document. Also, remember that a will is a financial transaction. Simply state who you want to receive your assets. Don't put in statements such as, "I love my family very much." Save that for some other means of communication. Write a letter or something separate. The same way that you wouldn't add emotional notes to a car title or a real estate deed, please leave these off of a handwritten will, a holographic will. There's some additional resources on the screen. They include lawhelpnc.org, North Carolina Courts website, which is nccourts.gov, has help with wills and estates, and it has actually a little brochure that they publish regarding estate administration and wills. The Secretary of State, which is sosnc.gov, has forms including advanced healthcare directives that you can use and download. The general statutes, North Carolina general statutes, chapter 31 deals with wills. Chapter 29 deals with intestate succession. Chapter 32C deals with financial powers of attorney. You can also reach us at Legal Aid of North Carolina. Our toll-free number is 866-219-5262. or our senior helpline at 877-579-7562, or at our website at legalaidnc.org.
I'm going to leave these resources on the screen. That does wrap us up as far as content. So now is our time for questions. Is there anything else you wanted to go over, Janet, before we swap to questions?
Nope, I'm good.
Awesome. All right. Well, as a reminder, folks, if you have a question, now's the time. You can put them into the comment section on Facebook or the Q&A box on Zoom. I'm going to give it a little bit, see if anything comes through as far as questions. And while we wait on those, I wanted to go over a couple things with you all. As we talked about earlier, we do listen and learn fairly regularly. We are currently offering them on a variety of topics from what we did today. So healthcare, I should say living wills and all of that, and advanced directives. We also do criminal record expunction. We do Medicaid and benefits presentations, food stamps, a whole host of topics. You can register for those by visiting our website at legalaidnc.org. You can also watch any of the recordings of these presentations, as well as this one, on our Facebook page at facebook.com/legalaidnc. You don't need a Facebook account to view it. You just simply have to have access to the internet. And again, it's facebook.com/legalaidnc. Gonna do a final call for questions, folks. If you have one, now's the time. Looks like we're not having any questions today, Janet. So anything else you want to say before we wrap up?
Something just popped up.
Oh,
Question in the
fantastic.
chat. It says, I've got a power of attorney with me being the agent for a friend. The nursing facility is wanting me to sign saying I'm something, I can't read it. Again, we can't answer specific questions. I apologize, but you are not our client, so we can't really provide information that refers to specific information. If you have questions, you would really need to consult with an attorney about what your authority is.
Any more questions, folks?
Yeah, there's one more. Oh, she just says, am I responsible? And again, I'm so sorry that I cannot answer specific questions and give specific advice about certain situations. So in order for you to do that, you would have to hire an attorney to, to discuss that with you so that you would have confidential information. Okay, I don't see any other questions.
Yeah, perfect. All righty. Well, folks, that's going to wrap us up for today. I want to thank you all for joining us, and thank you to Janet for presenting. Again, if you want to review any of this content again, get a refresher on anything you heard, you can watch the recording at any point starting now on our Facebook page at facebook.com/legalaidnc, or register for more of our Listen and Learn webinars by going to legalaidnc.org/clinics. Again, thank you all for joining, and we will see you in the next one. Have a good day, everybody.
Thanks.